Afternoon, Your Honor. Nick Boutros on behalf of the plaintiff.
Travis Gagne on behalf of defendant, trust, and the tenant.
All right, where are we on? I hope we got to the point that I am not going to hold the neighbors today. That's not how they're set by this court. Never have. But where are we on this?
That's fair enough, Judge. Witnesses still came just in case. Still not resolved. So I think we need to set this for trial.
Sure. I mean, I can't disagree with the fact that it isn't resolved. I don't know, based on our last hearing, if it's worthwhile having a motion on this. I don't know if it necessarily needs discovery or whatnot. I think that, you know, in this case, there was no request to remove the tenant. Everything has been cured. I think that can be cut out on motion and the case dismissed.
Your Honor, the complaint does request repossession and eviction of the tenant.
So I know that's the request. I'm saying the cure letter did not, and everything in the cure letter has been cured. So I don't think it's a matter of law. This needs to go forward.
What are the fundamental issues?
Fundamental issue, Your Honor, is that we have a tenant that is creating extreme noise by hitting the walls, throwing things. There have been over 13 police visits to this unit owner. He's evaded pretty much every one of the encounters with the police, except the one where he was found on the street behind a post office. The Center for Community Health has tried to get a hold of this individual to see what's going on. There's several noise complaints. And
has CMH been in touch with the person?
Not that I'm aware of, Your Honor.
Are you aware as to whether or not the individual is a CMH consumer?
No. Why CMH is involved, I do not know. But there have been welfare checks as depicted in the police reports. It's been going on since 2024. I did talk to the tenants that are next door to him that share a common wall, and this is still going on today. So to say that this is resolved,
as I recall, there's the trust is exit.
correct.
And the tenant, the individual that you speak of, is a tenant of the trust.
Correct. Upon information and belief, we also believe it's the son of the trust administrator. It's the trust of the James Heaton Trust, and we believe that the tenant is the son of James and Elaine Heaton, or Ellen.
And you're saying this is a 30-day, but there's a lease, correct?
I don't know if there's a lease.
Okay, but right, you probably wouldn't. Is there?
Yeah, copy of the lease.
There is no lease.
No.
Well, what do you mean there is no lease? But you guys wouldn't know. You wouldn't be.
We wouldn't know. We're the
privy
association.
to the lease.
Right. Defendant's counsel would know, or may be able to get that information.
But you're seeking to evict pursuant to what ground, I guess?
Violation of the master deed and bylaws of the association pursuant to the Michigan Condominium Act. And that's specifically MCL 559.212, which allows the association to evict a tenant or co-owner based on violations of, or to initiate eviction proceed based on violations of the governing documents. Governing documents here prohibit unreasonably noisy activities. And as either the testimony or the affidavits will show, is that the tenants next door have been dealing with this issue for over a year, where it's prohibiting them from sleeping at night. The police have come to the scene, observed significant holes in the wall. The door is damaged. The door frame is damaged. And they have as well observed reports of screaming as well from this individual.
Yeah, but the damage to the premises, that's not the association's issue.
Well, it's still a violation of the bylaws to maintain the unit in good condition. But the main issue here is the noise.
Your Honor, that's not been alleged in the complaint or in any of the demand letters. There's been an allegation in the demand letter, which was attached to the complaint, that the door frame, exterior side of the door frame be fixed. That was fixed within the allotted time that was in the letter. That has been cured.
The door frame was not fixed.
Ma'am, that's not how I work here. I need your name so the record, since you interrupted counsel.
Sorry, Your Honor. This is
Camera CCAP.
the representative of the property management company.
Go ahead, counsel. What were you saying?
My understanding is that the door frame was fixed when it was requested. The exterior part of the door frame, again, to Your Honor's point, anything on the interior of the unit should be between the owner and the tenant themselves. There are no allegations as to common elements that have been damaged here. Responsible. This is between the tenant and the owner. I've also looked in the police reports that have been provided. There have been no citations. There have been no prosecutions on this. There have been nothing good on this. Police coming out. The reports we found, I haven't been able to find anything where they've observed noise into the unit themselves or itself. That in the report, belligerent or loud police officers in that report, they let him go after talking to him on his own recognizance.
Judge, we have one of the officers here today. There's been a noise ordinance violation issued specifically on November 9th, 2025. There was another
To whom?
to the tenant, which I don't have the name because the FOIA records are blacked out. But it is issued to the tenant. There was another violation that was issued on noise violation on November 20th, 2025, but that was dismissed for lack of evidence by the prosecution. When they, on October 31st, 2025, when the police were able to make contact with this individual when he was found walking down US 12 and hid behind a post office, I believe it was a dumpster. When they asked him what the noise was, he just said that he was not going to answer.
Okay. And what am I supposed to do with that? I mean,
There are reports of
the citizen in the United States and the police officer walks up to him, asks him a question,
correct.
saying he's
I'm not.
answer.
No, I'm saying
Okay.
he still can invoke his Fifth Amendment right to.
Well, I don't know if it's Fifth Amendment. I don't just have to talk to you if I don't want to.
Either way, Judge, there have been noise violations issued by the police department.
So what's happened to those noise violations?
There's the November 9th, 2025 noise violation. I do not know. I don't have those records. The November 20th was dismissed.
What's the name on the violation?
It's blacked out.
Your Honor, I can look into the November 9th one. My understanding was that any violations have not been prosecuted because there's been no evidence. Support them. So
Oh, that's what I'm trying to get. I mean, and right. If I had a name. Tenant. So, but the noise violation wouldn't it have been entered in the owner's name?
Not if the tenant is the one causing. Perhaps the police could have issued a violation against both, because ultimately the landlord
Oh,
is
did they?
responsible. No, not that I'm aware of. But that's something we can flush out with testimony, Your Honor, from the police department.
Well, but you want the officer to testify? Did you ask him? I mean, I don't think these are really hard questions. I don't know what this has to be a mystery. I'm trying to figure out, are there citations that exist out in the Chelsea, well, they would be out in the Chelsea court, that substantiate the noise complaints? Question mark. Is there?
Well, there are police reports where the officers have observed screaming by this tenant, and every time they knock on his door, he goes silent and doesn't answer the door. They can't force entry. And we do have one of the officers here today who has a significant history with this tenant.
Okay. That doesn't answer my question. I understand that the officer may be able to testify as to certain things.
I have not asked the officer these questions yet, Your Honor, because this is the first day I've met Officer Kasser, and I have not questioned him. The Chelsea Police Department does not permit conversations outside of a subpoena. That's what we were informed by their subpoena department.
What?
When we asked for a conversation with the officer, we were told that we have to subpoena them. And the only way to issue a subpoena is to get him to appear to court. We don't have discovery open, so we could not take deposition.
All right, let me just tell you this. I don't know what you did, but I think if you wanted to talk to one of their officers about something, I don't. If you said they want you to testify, then they may have said, that's not happening without a subpoena. I could see them saying that. But if you wanted to have a conversation with an officer, I've never heard of the Chelsea PD doing. I've never heard of any PD in this county doing that.
Neither have I, Your Honor. But this is what
Chelsea was different.
This is what happened. This is the email string I read. We asked for a phone call, and they said you have to issue a subpoena.
It's my day. Okay, but I'm trying to figure out the citation. So I'm sitting here right now. Nobody's asked about any citations, noise complaints, or really? I mean,
Have reports of noise complaints from the tenants that live next door to him who are here today as well,
okay, but
who are most affected by this.
I understand that, but there are plenty of circumstances where neighbors don't like each other and they're complaining back and forth. I thought that there were citations that had been issued in this case.
There have been.
And then okay, have they been adjudicated? I mean, you keep answering that. Can you find it? You think you can find it? Have at it, because nobody else is giving me an answer. I mean, and I'd ask the officer, but apparently talk. I'm kidding.
He is subpoenaed.
You have them? Mr. Allen, can you? Thank you, officer.
Judge, the citations attached to our exhibit 5.
I saw what you filed, but you got a citation. You have it. Well,
Hopefully he really
you get it. Got it. This one hasn't, I got one. Number 25352. That one has not been adjudicated. That was allegedly offense date of November 9th, 2025. That has not been adjudicated. And there is a warrant on that case for a failure to appear because apparently a misdemeanor citation is issued. There is another one, 6-3. This is more recent. 0106 with an offense date of January 4th, 2026. That is set for arraignment April 20th, 2026 before Judge Freshour. So, Mr. Allen, the officer needs respect. And thank you, sir. So, really, we're going to need to have a hearing date. That doesn't sound to me like even the final settlement conference. You indicated you wanted to file a motion, counsel.
I mean, whatever the court's preference is here, if you want to move it towards another hearing, or if you want to have it be a motion hearing, I'm amenable to both.
Well, are you intending on filing one, or, I mean, do you know?
I would like to move this towards the final resolution. I don't want to,
I got it.
if the motion moves it forward, then great.
Why don't I set this for a non-jury trial? And if in the interim, counsel, you want to file a motion, certainly I will state this on the record. You can file a motion. I will shorten any response time to 10 days before the trial date. It can be set on the same date as trial. I'll just hear it.
Hearing on the same day as trial.
If there's a motion that's filed, then it needs to be filed at least 10 days before the date I'm about to give you. That way I can get a response and then I will address the motion on the date of trial.
Actually,
And then the response would be due.
Okay, here's how this works. If he files it, your time frame for responding is 10 days. So if it comes to me the day of the trial, I'll read it. I'll be able to analyze it and answer it.
Okay. Well, I may file a motion as well, Judge. I just want to.
Okay, same rules apply.
Yeah, that's why I'm asking.
Set the fifth. But I'll set it, if it works for council, schedules May 5th, 2026 at 9. And
9 a.m. on.
yes,
That works for me.
that works.
I'll make it work, Your Honor.
And the witnesses, I know you guys are down here under subpoena. Is that going to work? Is anybody going to have a hardship with that?
May 5th.
No. May 5th, 9 a.m. Great. Thank you, folks.
Your Honor. Have a good
Thank you,
weekend.
Judge.
Once I get, I will. All right.
What started as a simple noise complaint quickly unraveled into something much deeper: missed court appearances, active warrants, and a system struggling to pin down the truth. This case shows how small disputes can spiral when accountability slips through the cracks. The judge wasn't just looking for complaints, he was demanding proof, structure, and real legal footing. And without that, even serious allegations can stall in court. Now, the real question is, when this goes to trial, will the evidence finally match the accusations, or will this entire case fall apart under scrutiny?